welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Jose Estegaraga, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights, and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hello, everyone, and welcome to the latest edition in our Arbitral Insights podcast series. I'm Gautam Bhattacharya. I'm a partner in the London office at Reed Smith, and I'm very, very delighted to be joined by my colleague, Joyce Fong, who is a senior associate in our Singapore office. Hello, Joyce.
Hello, Gautam. It's very nice to be speaking with you today.
Oh, it's my pleasure. And, just so everyone knows, although I'm based in London, I was based in our Singapore office for 3.25 years. And I worked very closely with Joyce while I was there in Singapore. And I've also had the great pleasure of working with Joyce since I've been back in London. And Joyce and I have just recently finished a case. And we thought it would be very useful if we could share some practical insights and some of the perspectives which we got from that case, which was an international arbitration seated in Singapore, which threw up some very interesting points on the cross-examination of factual witnesses in arbitration. And especially when the parties are from different jurisdictions, are not used to the arbitration process, are not necessarily conversant or fluent in the English language, which was the language which governed the arbitration, and where not every jurisdiction is going to have the same level of familiarity with the importance of document retention, document creation, and other aspects like that. So Joyce and I thought it would be very useful for us to just talk through some of those points with you all today. So I wonder, Joyce, if I could just sort of start off by asking you to summarize for our listeners, what is the crucial role that factual witness testimony plays in international arbitration?
Thank you, Gautam. So factual witness testimony is very important, especially when you need to prove disputed facts where they cannot be proved by written evidence. So sometimes you've got gaps in, for example, emails and documents, and you just can't piece together the facts. So that's where a factual witness is very helpful to help people understand the context and the thinking of the parties when they were doing a certain thing. And sometimes you also have the situation where you've got a contemporaneous document, but where, just reading the text itself, it's not very clear what exactly the sender means. They could mean one of several things if you take the literal translation, but having the person who sent the email explain what they were thinking and what they meant, provide some context to help the reader understand the content of the document.
Thank you, Joyce. And, the importance of witness statements is something that's not limited just to arbitration. It's also something that's very prevalent and well utilized in litigation.
Yes.
And there's also been a recent ICC report on the accuracy of factual witness evidence. So I wonder whether you could just summarize for our listeners some of these recent key developments, not least because witness statements are something which not all jurisdictions are familiar with, because some jurisdictions don't have the concept of witness statements. So I wonder if you could therefore just touch upon some of the recent changes in the English litigation procedure, which of course you're very familiar with, and also the recent ICC report on the accuracy of factual witness evidence.
Yeah, sure. So, the difficulties which the tribunal or judge faces in trying to obtain an accurate recollection of events from factual witnesses, this is a very hot topic in the disputes world. In the English courts, the business courts have recently introduced very strict rules on trial witness statements, the aim being to make the drafting of witness statements more transparent to ensure that the witness statement that is submitted in the hearing, that is the witness's own recollection, the witness's own words, and not the lawyer's narration of the events, which is then sent for approval to the witness. And the English judges are taking this very seriously, and there are very strict rules that are imposed on practitioners. So you have to, a lawyer such as you and me will of course have to sign a statement at the end of the witness statement confirming that you've abided by the requirements of the CPR in preparing the witness statement, to confirm that all the checks and balances that the English courts have requested have been complied to the letter in preparing that witness statement. Similarly, in arbitration, this year the ICC published a report on the accuracy of fact witness memory in international arbitration. It is a really interesting report because it highlights that, memories are not, a person's memory is not something that is fixed, it's malleable. So if something happens today and you ask me about it in 5 years, my recollection of what's happened may be affected by the things that occur between now and then. And this is not to say that the witness is being malicious or deliberately trying to hide or distort the truth. This is just that there is research which shows that this is just a natural occurrence which happens when a person experiences various events between, something actually happening and the time when the witness is being asked to recollect what has happened.
Thank you, Joyce. That's a very, very helpful summary. And, one of the things which we take for granted is that many cases will involve witnesses who are very familiar with the arbitration process, who are very familiar and confident in the English language, and that sometimes documents may not be in multiple languages. They may just be in English. But I think some of the practical lessons which you and I learned from our most recent case working together is some of the issues which arise where multiple languages are involved and where witnesses are not always familiar with the concept of documentary disclosure and the fact that documents in the course of the last 4, 5, 6 years before the arbitration will have to be disclosed as part of the document disclosure process. So I wonder if you could just tell us a few of the practical points that you feel have arisen where multiple languages have been involved.
So, as you say, in our recent case, there were documents which were in multiple languages. Actually, they were a mixture of foreign language and English. So you have situations where you have a document and both sides are producing translations that differ. So, for example, we had a case, we had a document involved where the literal, in this case it was Korean, the literal Korean text said, "I think something on mind." One side came up with a translation that said, "I think he has something on his mind," whereas the other side came up with a translation that said, "I think you have something on your mind." So completely different meanings, referring to completely different people, but the sender and recipient were both witnesses in the arbitration, and both were of the view that their translation was the right one. So it could have been a miscommunication which happened at that time, or it could also be that the gaps in the wording can support multiple translations, and because it's been so long since the event occurred, it's very difficult to say for sure that one witness has an inaccurate recollection of events. And I think this is especially a problem where people are using instant messaging, because we tend to not type in complete sentences and not to give context. So, for example, you and I, Gautam, might be exchanging emails on a topic, and then I may decide that actually it's easier for me to just quickly send Gautam an instant message on the side to quickly explain what's going on. So if someone reads the email, they may get a bit of context on what's going on. But if they only have access to our instant message, they'll be asking themselves, scratching their heads and asking themselves, "Oh, what is she saying? Why is she saying this? What does she mean when she says he?" So many people who could have been involved. So context is very important. And without context, there's bound to be differences in interpretation of documents.
Absolutely. And I mean, that's a very nice summary of the issues which we had. And, and where a witness, I mean, of course, we can't talk about specifics of the case. But, if a witness chooses to give evidence in a different language, so if they don't feel confident enough to be cross-examined in English and they want to give their evidence in their, if you like, their native tongue, tell us a little bit about some of the practical lessons which we learned most recently from our case.
So I think I've observed that there is actually a spectrum of witnesses who give evidence in different languages. So you have on the one end people who may not understand English at all, or who have a very, very basic understanding of English. Or you have someone who is actually pretty fluent in English but wants a security blanket, just to help them if they blank out or if they panic. So you've got a spectrum. And I think the situation is hardest the less fluent a witness is in English, because then the witness can't really be a check and balance against what the interpreter is saying. So, for example, if the witness is asked a question in English, if he or she understands English, then they would have had some understanding of the question the first time round. And then the translation just serves to reinforce or clarify that understanding. So that's given him or her a bit of time to think about the question and what his answer is going to be. But if the witness has zero understanding of English, then what happens is he or she is hearing the question for the first time from the mouth of the interpreter, and then having to think about it while everyone is waiting for the interpretation, and then giving the answer in their native tongue, and then waiting for that to be translated. I mean, the whole process is very long, and for an observer who doesn't speak the language, it can be quite tedious, and it's very easy for people to zone out during these times. So, you've got to be very, very careful about how the witness comes across. But you mentioned earlier, Gautam, that people, if lawyers and parties come from different backgrounds, then these may raise extra issues. And this is definitely the case, especially in international arbitration, where you don't have a lot of fixed rules. You have what you call soft rules based on parties' practices. So, if you've been working with a certain group of law firms on the other side for several arbitrations, you kind of have an understanding of how things should work and things should happen. But if you're working with lawyers from a different jurisdiction for the first time, they may be used to one thing and you may be used to another thing. So just some kind of practical points that arose from our arbitration. So there were a few benign, what seemed to be benign points that the other side raised objections to when it occurred. So, for example, the use of in-house interpreters to help witnesses. The other side, made a song and dance about this as being an attempt to unduly interfere with the provision of evidence during the hearing. Similarly, the use of glossaries of terms to aid interpreters, again very benign, and the other side were given the opportunity to comment on the glossary itself, but then they decided that actually they didn't think it was appropriate. Another issue is the extent of pre-hearing discussions between the witness and the interpreter. Interestingly, on this one, on the case that we did, the other side was not happy about any pre-meeting taking place. Again, they suggested that our client would use the meeting to improperly influence the interpreter. But the funny thing is, on another arbitration that I've done quite recently, it was almost taken as given and accepted that the witness and the interpreter would have a pre-hearing discussion, just to introduce themselves to each other, break the ice, get the interpreter familiar with technical terms or acronyms which may not be so obvious from reading the witness's statement. So, I do think these are helpful discussions, and obviously, if parties are not, both sides cannot reach an agreement, then you can't do it. But it's just one of those things where it's meant to be benign, but if the other side is not used to it, they may see it as an opportunity, an attempt by you to improperly gain an advantage for your client in the arbitration. When situations like that happen, it's sometimes helpful to have a tribunal member who's fluent in the language to just act as a check and balance. So in our case, we were very fortunate to have a tribunal member who was fluent in the language. And at certain junctures, he was able to intervene and just say, actually, this is what the document says, this is my reading of the document, or actually, this is what the witness has just said to the interpreter, just to avoid any flare-ups between the parties arising from misunderstanding.
because you're right. I mean, some words have particular meanings. They have a technical meaning, which is not just the everyday meaning. And even in the English language, there are some words which mean one thing to someone and mean something else to somebody else. So this is something that's certainly an issue. And, being specific about meaning is critical, especially in a case because words can have different meanings. So, Joyce, just to wrap up, I think we've got just the last thing I wanted to ask you is, bearing in mind the points that you very helpfully raised so far from a practical perspective, during the hearing, what sort of tips would you give for parties to be mindful of when they have the situation or a similar situation to the one that you and I have been discussing?
So I think the key, as always, not just for arbitrations where you have foreign languages, is keep the questions short and simple. The longer your questions are, then the higher the chance that the questions lose their meaning in translation. From more pragmatic point of view, a long question also requires a long translation, and your interpreter it increases the risk of the interpreter making an error in recording what you've just said and translating. So I think you do want to keep your questions short and sweet. Also, try not to use words that are too technical or too difficult, because you do not know that your word is going to be translated properly to the witness. So where possible, I would say try to keep your questions simple, using simple words. And, if you're the party that's adducing the witness, then obviously pre-brief your witness, make sure the witness is aware of the do's and don'ts of the arbitration. I mean, even in our case, sometimes the witness may naturally, for example, witnesses shouldn't be having their own side conversations with the interpreter, because then no one understands what they're saying. But in the hearing that we did together, Gautam, the witness, it was just a natural descent into a conversation because he maybe misheard what the interpreter said or couldn't understand what she said. So literally all he did was, ask the interpreter for clarification. But when there was a bit too many of these back and forths between the witness and the interpreter, the other side pounced on the situation and basically said, oh, no, this is very inappropriate and should not be allowed, and tried to cast aspersions on the witness. But as I mentioned earlier, in our case, we were very fortunate to have a tribunal member who spoke the language and who was able to just confirm independently that actually the exchanges are completely innocent. So these things do matter. And then I think the final point is, as always, pay attention to the tribunal. If a tribunal is looking bored, you may want to maybe take a break or change the style of cross-examining. Similarly, if it's your witness, then, I suppose you may just want to make sure that the tribunal is paying attention to the key points your witness is saying. Otherwise, it may all be for nothing.
Thank you, Joyce. Now, those are very, very practical and helpful points. And, it reminds me of a case that I did many years ago, which was a litigation, which involved having an interpreter, in the box for a long time with the witnesses. And there were a number of witnesses. And the process of translation is very mentally tiring for the interpreter as well. So having regular breaks is good for everybody, the interpreter, the witness, the tribunal, the counsel, because following translated language from one to the other and then answering the question, then translating it, is very tiring and really does need to be done as effectively as possible. So, Joyce, thank you very, very much. That was a really, really useful, practical run through these points. We hope our listeners of this podcast will find it helpful, and we look forward to doing further podcasts for you. But for now, Joyce, bye-bye, and speak to you soon.
Bye, Gautam. See you soon.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email Jose Estigaraga at jia@reedsmith.com. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. All rights reserved.